Okay, Bismillahirrahmanirrahim. Now I want to discuss the question number 1 in week 5. So the question is find case involving halal import product. The case that I found is REPT Garuda Food Putra Putri Jaya TBK 2019 11 MLJ 396. The fact of the case is the applicant was an Indonesian company that made and sold, among other foodstuff, a popular cracker biscuit of various flavor under the brand Gary. The products made for the Indonesian market were different in quality from those made for the Malaysian market. When the applicant discovered that the products meant for the Indonesian market had been imported into Malaysia without its knowledge and were being sold in Malaysia, it filed an instant ex parte originating summons (DOS) identifying the infringing products and seeking a declaratory order that they were false trade description under the Trade Description Act 2011, the TDA. It was only if the infringing mark was not identical to the registered trademark but could be passed off as the latter was an aggrieved party required under Section 9, Clause 1 of the Trade Description Act to apply to court for a declaration that the infringing mark was a false trade description. Held, the court was empowered, if so moved, under Section 9, Clause 1 of the Trade Description Act to grant a declaratory order of false trade description where the infringing trademark not only resembled and could be passed off as the registered 396 Malayan Law Journal MLJ 2019 11 MLJ trademark but was also identical to the registered trademark. In other words, the option was open to an aggrieved party to resort to either Section 8 Clause 3 or 9 Clause 1 of the Trade Description Act for infringement of an identical mark. Section 38 of the Trademarks Act 1976 provided that a registered trademark was infringed by a person who used a mark identical to it. Hence, in that instant case, it was still a trademark infringement notwithstanding that genuine products which carried the mark were brought in through unauthorized parallel importation. The registered trademark owner had the right to take legal action against the parallel importers and those connected with them for trademark infringement. It was particularly pertinent here because the products were foodstuff and there was a need to ensure that they meet the necessary Malaysian quality standard and health ministry requirement to protect consumers. The infringing products might pose a health and safety risk to Malaysian consumers. Example, the freshness of the product would be of concern. There might be expired products in the Indonesian market. Public interest as well as the reputation and goodwill of the applicant were at stake here. That aside, the parallel importation of the products was also an unfair business competition to the applicant and its authorized exclusive Malaysian distributor.